Hi, everyone. Just waiting a second for everything to get connected, and then we will dive in and start going. Waiting on Instagram here real fast. There we go for that. And then we'll get TikTok going. All right. Hi, everyone. Welcome to today's live. I am Holly Draper. I'm the CEO and managing partner at the Draper Law Firm, which is a family law firm in the DFW area. And today we're going to be talking about mediation. Mediation is something that you are almost certainly going to come across in any type of family law case. It's mandated in almost every court, certainly every court I've practiced in, it is required unless there's domestic violence involved. But even then, I would still recommend it. You just do it via Zoom so you don't have to be in the same room with, or in the same facility with the other person. So anyway, first, what is mediation? Mediation involves a neutral third-party mediator who helps to facilitate an agreement between the parties. Mediation, yes, it occurs in family law cases, but it occurs in all types of litigation. So this is a normal legal process that we go through. It's not a trial. There is no judge, and you cannot be forced to settle. However, most cases do get resolved with mediation. It's very common. We hear it every day from clients. Why would I go to mediation if we can't settle this without mediating? If that were the case, mediators would not have jobs and nobody would have to go. The reality is that I would say 95% of the cases in our firm get settled at mediation, and most of those couldn't have gotten settled without it. You need that neutral third party. You need everyone sitting down in a room, not together, but separate rooms, working with the mediator to get that case resolved. Mediation is a great idea for coming up with solutions to all types of family law problems. And the best thing about mediation is that you can get creative and you can do things that a judge could never do. Judges in family court are very limited by what is in the family code as to what they are able to do. They cannot give you creative schedules. They are not going to have the time or enough information to really learn about your family and really learn about what would be best for you. So by being in mediation, you and your ex get to be in control of what happens with your family. Now, I know you and your ex are exes for a reason, and you might not get along in a lot of ways, and there are probably almost always going to be things that you don't like in your final agreement. But it's about compromise. There's some mediators out there I've heard joke about, if somebody leaves happy, we didn't do this right. Both sides have to give, but you should, at the end of the day, have resolution and know what's going to be going on. You don't have to go to trial. You have hopefully gotten some of the things that were important to you. The other side has gotten some of the things that were important to them, and you've done what is best for your family. Do you need an attorney to go to mediation? I see every day people posting that in various Facebook groups that, should I get a lawyer or should I go to mediation? You should get a lawyer and you should go to mediation. It is really risky to mediate without a lawyer. And the number one thing, even if the mediator is a lawyer, which they are not all lawyers, but even if your mediator is a lawyer, they cannot give you legal advice. Their job is to get a deal done, not to look out for your interest, not to make sure that it is fair. We say fair is a four-letter F word, so we try not to use that in the context of family law settlements, but they're not looking out for you. They're looking out for the deal. By having an attorney, you have someone who is going to look out for you and who is going to make sure that you're protected, make sure that you're not forgetting anything, make sure that, at the end of the day, you're going to end up in the best possible place you can be. And unless you're a family law attorney, you don't know what you don't know. So the advice you got from your friend about what happened in their divorce or their custody case, or what ChatGPT told you to do, or whatever, is not the same as having an attorney there in real time to give you the legal advice to make the best decisions you can as you mediate. Next question is, how do we prepare for mediation? So at our firm, particularly in a divorce, we really need to exchange information in advance. On the property side, you have to have all of the information in order to make reasonable decisions. Sometimes we'll have clients who choose not to do an inventory and exchange, or inventory and appraisement. That can be really risky. Sometimes it's okay because the parties really haven't accumulated anything, or everyone or our client is really confident that they know what's there and what's not. But usually we're going to exchange sworn inventory and appraisement in advance so we can look through it, make sure there's nothing missing or any holes or whatever. Sometimes there is information we would want to exchange in advance in a custody case. Is child support an issue? Do we need pay stubs? Are there school records we want to see? It could be any number of things, counseling records, a lot of things. So at our firm, excuse me, when we are preparing for mediation, we are always going to have at least one, sometimes more than one, mediation prep session with our clients. We do this for a few reasons. Number one, we want to set reasonable expectations with our clients. I cannot tell you how many times it is clear that the other side has not done this, and the other side comes in thinking they're going to get the child 100% of the time, or they're going to be able to move to New York City, and while the other side is staying here and wants access to the child. And it takes a long time in mediation for the mediator to knock them off of those unrealistic expectations that are never in a million years going to happen in court. So we try and do that in advance so that when we get there, we aren't having to waste time knocking someone off of something that is never, ever going to happen. Now, sometimes it's hard to hear those realistic expectations because, we see, especially in custody cases, parents who really think that their child is never going to make it, having to go spend 40% of their time with the other parent. Or that person has never parented before, and the other side has never parented before. They cannot take care of this baby. They should have no access. Those are just unrealistic expectations that we are going to have to work through. On a divorce side, we see a lot of unrealistic expectations about what's going to happen on property division. How much is that affair really going to impact property division? Yes, it stinks that your spouse cheated on you, and that is a very hard and emotional thing for people to work through. But at the end of the day, we know what a court is likely to do with that information when it comes to property division. So we, again, want to set very realistic expectations with our client of what they actually can get, because you don't want to bust up a settlement for something that is never going to be happening in a courtroom. Next, during our mediation prep meeting, we work on making an opening offer if we are the side that's going to make it. If we're not, we still want to talk about what do we want that settlement to look like? What are our goals? What are our priorities? And we also want to know, what do we think the other side's priorities will be? Sometimes somebody really cares about keeping the house, and that's a huge priority. Sometimes somebody really cares about retirement. Sometimes somebody really wants to have the kids going to their church with them. It could be anything. And if you don't talk to your lawyer about what your priorities are and what's really important to you, then your lawyer can't know when you get to mediation to make those things priorities. And we have the things that are, standard in every custody case, but there could be things that are important to you that aren't standard. Perfect example. If Halloween is a huge deal in your house, that is not a standard holiday in a custody order. So you should be talking to your lawyer about the fact that Halloween is really important. My spouse doesn't care about Halloween. I want Halloween every year. Or everybody's going to think Halloween's important, but we need to alternate it so that the kids spend both time with both parents on Halloween, or we need to split the day, or whatever the case may be. Or Easter, or if you celebrate a religion where your holidays are not part of the standard holiday schedule, are those important that we figure out a way to work those into your schedule? Following a mediation prep session, our office always sends a mediation statement to the mediator. I know a lot of attorneys don't do this. I see it all the time where the mediator has no idea what's going on or what the other side might be thinking. We want to give the mediator as much information in advance as possible because it saves a lot of time at mediation. We don't have to waste the first hour of the day going through the history and who our client is and who the other side is and what's important to them. We've already told the mediator what the case is about. We've already told them what we expect the big issues to be. We've already told them, kind of maybe what's really important to our client and what we want to see happen in this mediation. It's unfortunate that not all attorneys do this because it really bogs things down, but it's definitely something our firm always does. So now you are at mediation. What actually happens there? Most mediation can happen in person or it can happen via Zoom. I personally love mediating via Zoom, and I think everybody on my team agrees with that. People are just more comfortable when they're mediating from their own home. They can get up and go grab a snack. They can get up and go snuggle with their dog or whatever makes them feel more comfortable. They can be wearing their sweats, people are more comfortable and they seem to make it better through a long day when they're in their own home. There are certain situations, I think they're relatively rare, but they do exist, where one side or the other is really going to say, I think we're going to need to be in person. It could be for any number of reasons, but there are still mediations that happen in person. When we are mediating, whether it is in person or via Zoom, you and your lawyer will be in one room and the opposing side and their lawyer will be in another, and the mediator will go back and forth between those two rooms. That could be a Zoom room or it could be a physical room. Occasionally, a mediator will pull out one or both attorneys and kind of talk to them privately and try and hammer through some issues. But generally, you're never going to see your ex. You're never going to be in the same room with them. You're never going to have to try and negotiate directly with them. That really helps to de-escalate things and help, keep it focused on getting towards an agreement. So the mediator goes back and forth trying to hammer out the terms of an agreement. Sometimes we go through all the issues at once. Sometimes we have to break it down and, okay, let's talk about the possession schedule first. Let's see if we can get somewhere on that. Okay, now let's talk about rights. Let's talk about the property division, whatever the case may be. So what happens if we reach an agreement? Which again, vast majority of cases will reach an agreement at mediation. If you do, you get what is called a mediated settlement agreement. You'll hear lawyers referring to that as an MSA. You could have a full MSA that resolves all of the issues in your case, or you could have a partial MSA that resolves only some issues. And then you still have the remaining issues for trial or to try and work out an agreement down the road. This is critically important. If you sign an MSA, it is binding. There's no sleeping on it and having buyer's remorse and coming back the next day and saying, hey, I really don't like this deal. I want to pull out of it. Nope, too bad, too sad. This is the most binding contract you can get yourself into is an MSA. And that's good because everybody at mediation can leave with the confidence in knowing that we did the work, we got a deal. Nobody's going to back out of this now. There are some very limited exceptions for fraud and duress, but I have honestly never seen anybody successfully make those arguments. I've seen a few people try, but it is critical to understand this is a done deal. Now that MSA is going to have to then, after mediation, get turned into a final order. One of the other realistic expectations we need to set is how long does that take? We have clients sometimes thinking after mediation, boom, boom, we're going to be divorced or it's going to be done really quickly. And the truth is that it is often not that quick. One side or the other is usually it's the petitioner, but not always, is going to be told to draft the final order based on the MSA. The MSA is going to say who it is that's going to be drafting the final order and how long they have to do it. It could be 14 days, it could be 30 days. It could be any number, but usually the MSA is going to say those things. Sometimes attorneys will kind of negotiate that or want it changed as part of the MSA because they know it's going to take longer for whatever types of reasons, because certain cases are more complicated. Sometimes we're going to need to dig in on property stuff, or we're going to need to figure out agreements on whatever to get those things into our final order. So it does take a while. And keep in mind that both sides, the attorneys have other cases. This is not the only thing they have going on. They generally will get it done within that timeline. We always try to. Sometimes we'll ask the other side if we can have longer for one reason or another. Sometimes the other side will ask us. Sometimes the other side doesn't get it done when they're supposed to. And then our choices are either to do it ourselves or file something with the court to try and force them to do it. Usually we're going to have to do it ourselves and file a motion to enter if the other side is not cooperating. If the other side doesn't have a lawyer, we're always going to be the one drafting it. Once you get that, and your MSA might be 5 pages long, 5 to 10 pages, depending on how many issues there were, if it was just custody, if it was property, if it was both. But that final order, particularly if we're talking about a divorce with kids, could end up being 50 pages. There's a lot of things that are shorthanded in an MSA that are going to have to go into your final order. And it takes a while to prepare a 50-page document and to then send it to our client to review and answer any questions and make any changes that we need to. And then we send it to the other side or vice versa for them to review and do the same thing. Sometimes there's back and forth about, changes or what does this mean? Sometimes you have to go back to the mediator to help them resolve a drafting dispute for certain types of issues. We try very hard in our firm to preempt anything like that happening by making sure the MSA includes all the important things. Sometimes you can't help it, and there's just a weird issue that pops up, and we got to go back and get the mediator to deal with it. Once everyone has said, yes, this matches the MSA, these are the terms, everyone signs off on it, it gets submitted to the court electronically, at least in all the counties where we practice, and the judge will sign it. They could sign it that day, they could sign it that week, they could sign it next month. It just depends on that particular judge, how much they've got going on, how long that might take them. If one side or the other won't agree to sign off on that order, then the party that wants to get it entered has to file a motion to enter and set a hearing with the court, and then we go have a debate with the judge about what this order should look like. And sometimes the judge signs it then. Sometimes the judge has to make some decisions and you have to go change the order based on those decisions. Sometimes the judge needs more information and wants you to come back. So it can, depending on how complicated the case is, drag out for a while. So just kind of keep that in your mind about what a realistic expectation is to finalize and wrap up your case after mediation. But the terms are generally you're going to go into effect once you have that MSA, and but the MSA could say otherwise. It depends what it is. But hopefully that has answered some of your questions about mediation and given you some good information. If you are thinking about a family law case or you're looking at going to mediation and need some help, we would be happy to help you. Just send us a DM or go to our website, draperfirm.com, and reach out. Thank you.